far left is Conor Foley. He's a lawyer and head of business development at Marex. Among other past engagements, Conor was global head of government relations and public policy at Norton Rose Fulbright. He has an extensive experience in the derivative space, and he holds the Series 3 and Series 7 licenses. He undertook his legal training at PPP Law School in London. Megan Sierszulski, okay, thanks, is the head of legal and compliance services at Summit Financial Services, where she specializes in U.S. tax reporting and FATCA compliance. I don't know how you do it, but okay, among other things. Prior to Summit, she was in-house counsel for Velocity Clearing. She earned her JD at Boston College Law School, and she obtained her LLM at the University of Paris at the Sorbonne. So she's fancy. As for myself, in addition to serving as the chair of Maine's Regulatory Affairs Committee and also on the board, since 1992, I've been consulting to financial services firms of all types, broker-dealers, investment advisors, commodity pool operators, various types of funds, both private and public. When I started, I didn't know anything. So I had the whole consulting thing backwards, right? So everything I learned basically was in the industry, making mistakes and figuring stuff out. But now it's all perfect. I often serve as outsourced CCO and CFO for client firms. I'm also an academic, teaching, among other things, courses in business and professional ethics at Rutgers, applied ethics as well, and started teaching again at Malloy University recently. And I have a raft of FINRA licenses that I won't bore you with. I'll take the opportunity to hype the second edition of my edited volume, Understanding and Combating Global Corruption, which has just been released. And it appears that my next book will have to be Understanding and Combating Domestic Corruption. One housekeeping note, we decided that we will take your questions during the various panel presentations, and since there's not that many tonight, that's probably going to work well. So you can just ask questions as we move forward. And so before I turn to Megan, I'll let Megan kick us off first. Let me just give you a couple of my thoughts about the state of regulation. The panel topic was my idea for, I'm not taking no pride and privilege, pride of authorship here, but we have a lot going on in regulation, and it seemed like an appropriate topic, right, for us to have our first regulatory panel. So while my firm, my boutique consulting firm, is in the business of dealing with regulation, has been for a long time, I've been very unhappy with the fire hose of rules that have come out of the SEC under its last commissioner. I'm sure some of you feel the same way. Merely from a fairness point of view.
Yes.
Yeah. Fairness is important. Rules that would have required CLOs, for example, to have GAAP financial audits when they never had to be bothered with that, given the extensive layers of governance that allow managers to oversee CLOs and protect the investors. Rules that would have imposed U.S. regulation on unregistered funds, and that impose AML audit obligations on registered advisors, unnecessary in my view, to the burdens of small firms already drowning in regulatory minutia. And don't even get me started on regulation BI and the ridiculousness of, in my view, Form CRS. I've noted as well that what seemed to be capricious enforcement actions, in one case, Marathon Asset Management. Anybody from Marathon here?
Yes, I know, but I do know that it was frivolous.
Yes. Yeah, Marathon Asset Management had a rather high price to pay, $1.5 million fine, as well as public disclosures of regulatory censure, for merely not having incredibly specific MNPI policies and procedures with no finding of actual misuse of MNPI. As it turns out, Marathon Asset Management indeed had MNPI policies and procedures, like most of you do. And the firm even referenced service by its employees on issuer creditor committees. So the MNPI discussion involved, what do you do if you're on an issuer credit committee? But that wasn't good enough for the SEC. The relevant order issued by the SEC against Marathon states as follows. During the relevant time period, Marathon had certain written policies and procedures in place relevant to the treatment of MNPI, including its policies and procedures to prevent insider trading and information barrier procedures, dated December 2018, and its key Marathon MNPI procedures dated November 2020, which provided general guidance for evaluating and handling potential MNPI. However, Marathon's MNPI policies and procedures were not reasonably designed, according to the SEC, to address the risks specifically related to the potential for receipt and misuse of MNPI resulting from participation on ad hoc creditors' committees. Just let that sink in. For instance, the MNPI procedures listed several examples of situations where Marathon may become deemed to be in possession of non-public information and will require the relevant Marathon employees to consider including the relevant company on the watch list or the restricted list. The examples included were Marathon employees serving on creditors committee or restructuring. This is right out of the order. However, Marathon did not establish, maintain, or enforce policies and procedures for monitoring or supervising, specifically addressing the risk of receiving or misusing MNPI during participation in an ad hoc creditors committee. This, in my view, is an astounding overinterpretation of the requirement that an advisor's policies and procedures be reasonably designed to prevent and detect violations. No doubt, the Marathon procedures didn't discuss the possibility of requiring MNPI at the local country club either. That is not said in order to be glib. The SEC seems to be signaling that every single vector for rule violations must be written into advisors' compliance manuals lest a charge of willful violation be alleged. Should a registered advisor be found to be in willful violation of the Advisors Act because not all types of creditor committee is listed in the policy manual? I could go on. By the way, I'm rewriting the manuals of many of my clients that have become 500-page encyclopedias, probably yours maybe among them, because they're going to get the principals in trouble. A lot of check-the-box consultancies, law firms love to just dump stuff, not to offend the law firms. That's kind of their job. But back in 1989, when, for example, on the broker-dealer side, the requirement to have compliance manuals was introduced, they said at the very beginning, the manual should not become a tome. It should be useful, right? Not a book, not something that no one's going to use. So that's kind of where we are. Incidentally, Marathon is not a client of mine, never has been, so I'm just discussing this as an example. Now, to my brilliant fellow panelists, I'm going to toss the first question to Megan. What in the world is going on with U.S. regulation, Megan, since January of this year? Most specifically at the SEC. For example, a raft of rules have been withdrawn or compliance dates extended out as far as 2 years. In certain cases, certain rules that were finalized have been vacated by the court, so what's going on? Have fun.
Thanks for that, Dave. And thanks so much for that introduction, and thanks to our hosts for joining. Is this on? Okay, I'll speak louder. Yeah, a lot has been going on since January. I think we're in a brave new world when it comes to the regulatory environment, out of both the executive branch and the judiciary. So, since his appointment to the SEC, Paul Atkins, has made it very clear that his current stance on SEC regulation is to deregulate. So, Dave, I'm sure some of those deregulation points might, strike a chord with you as perhaps, something that might be necessary within the industry. That being said, I would also want to talk about the current judicial environment because, while we have Trump 2.0 with the, current regulatory environment with the SEC and FINRA, of course, we're going to be seeing, a lot of deregulation. I think that's very natural when we have a Republican president in charge. But I also want to go over some interesting legal cases and challenges that have been happening in the judiciary too, which, you know, by all accounts is supposed to be an apolitical branch of our government, right? But, you know, since we've had new Supreme Court appointments, we've seen some strange, I don't want to say strange, I guess we've seen some upsets, unusual upsets that have come down since, you know, I would say, you know, 2022 through present day. So I actually have a couple of, oh, there we go, great. So from the recent judiciary, you know, decisions, from SCOTUS decisions, we've seen some limitations on administrative and agency oversight, right? I mean, Paul Atkins of the SEC, he's had some opinions, of course, you know, as anyone does, to deregulate. But we're also seeing limitations on agency power from the executive, you know, limitations on executive power, as you know, because federal agencies are a part of the executive branch of government, right? We're seeing that come from the judiciary. And so I'm sure many of you have seen in the news the recent overturning of the Chevron case, right? As a bit of background, for those of you who are not familiar, Chevron has been, you know, this bedrock case of administrative law where basically in cases where agencies such as the SEC, the EPA, the FDA, if there is a statute on the books, you know, as drafted by Congress, as you know, Congress is responsible for drafting our laws and legislation, if there is an ambiguous or absent provision of a statute, and this is something that's contested before a judge in federal court, thanks to the Chevron decision decided back in the 80s, essentially the court would have to defer to the agency's interpretation of what that rule should be. So the thinking of the court at the time was that, you know, these agencies, they're experts in the field. They, you know, have they have experts that they employ. You know, if the SEC, they should know about certain products, you know, and this would be in lieu of a decision or an interpretation by a judge, right? That was the intention from Chevron. A good example of that would be, you know, the FDA is responsible for, you know, their oversight includes any sort of product or, you know, chemical that includes proteins. Well, there was a recent, you know, decision maybe, let's say 10 years ago, where there was a question over what is a alpha amino acid polymer, right? And the FDA, of course, had their own opinion of whether this is a protein, and then you have, you know, a court deciding, you know, I understand some judges are very smart, you know, but how could a judge possibly, you know, leave that to their own interpretation of what this is? That's where Chevron comes in to basically defer to the agency's expertise on this case, right? Until local right. So what happened there is, you know, we have this overturning of Chevron. Some legal experts might, you know, argue that it was on shaky grounds, and, you know, because Chevron has been implemented since the 80s, it has been cited in, I think, over 18,000 lower court decisions since the 1980s, since it came down. So now we have, the current Supreme Court has opened the door to perhaps judges' interpretations of what certain ambiguous or absent statutes might entail. So you have judges from all, you know, all sides of the spectrum, basically. So what this does, why people care that Chevron has gone away is, you know, there's now some uncertainty when it comes to agency oversight or rulemaking, right? And that power has now been pulled from the agencies themselves over ultimately to the judiciary, right? You now have courts and judges, and ultimately the Supreme Court now in a position where they could be deciding rules for the SEC, for, you know, the CFTC, FDA, EPA, everything, right? So I would say that, you know, since Chevron was struck down a year ago, I would say, you know, we're still waiting to see the impact it has on FINRA and the SEC, all these financial regulatory agencies, but I think it is very symptomatic of the kind of SCOTUS that we're seeing here right now. We've had this overturning of a bedrock case of administrative law that's going to have effects, I would say, for several years down the road. And on that note, SCOTUS has also taken up some other cases, which I've mentioned here. There's been some interesting developments, in the wake of Chevron overturning, where we have SEC versus, I'm going to say this name wrong, Cherkasy, where basically we are now seeing a further pulling away of power from the federal agencies like the SEC, where in Cherkasy, saying that wrong, essentially what happens is we had a litigant who had an administrative judgment against him from the SEC. And to give you some context, the SEC has been pulling away from enforcement actions for years. This is pre-Trump 2.0. They've been moving away from it. So I think when Cherkasy was decided, there was only a total of 7 SEC enforcement actions against securities industry participants when it came down. So, and with the holding of Cherkasy, basically the door has been thrown open where now SEC enforcement actions that are done internally by an administrative law judge, the Supreme Court found that basically for cases involving civil penalties like securities fraud, right? We want to punish a securities fraudster for defrauding their clients and hit them with a fine. Well, according to this case, it can't be done in an administrative setting. It needs to be done before a jury in federal court. So, we're now seeing enforcement actions now being pulled away from from the agencies and being put back into the court's hands. And so that's what we're seeing.
But there's a political logic to that. So what's the political logic?
I'm not going to comment.
Okay. I'm trying to make it interesting.
If anyone wants to put on their tinfoil hats, I think I will say that I would say conservatives in general, and I don't follow this very closely, they've had a bugbear with Chevron for a long time. I think they had this caricature of what Chevron is and what it does. They had this idea that, thanks to the Supreme Court case, which was actually in favor of a Reagan-era EPA decision, by the way, that it essentially handed so much power over to the agencies to basically make up their own rules and, have this power over, laws written by Congress that were supposed to be, enforced that way.
Sounds like the deconstruction of the administrative state.
You might be on something.
Yeah. I mean, I think it was a great decision.
Yeah, I mean, I'm not here to comment on I think
it was imposing incredible burdens on people trying to create emerging technologies and energy in the Midwest and in the South and in California still does impose administrative burdens on everyone. And there was
Could you give an example of the administrative burdens?
Mm-hmm.
What kind of burdens?
Just more regulation. And they
What is more regulation? More things to read, more things to comply with, more expense? So I mean, it's very easy to say that, but give us an example.
Well, this is going to be good.
I could talk to you about
But
one of my frackers in Colorado.
Okay, and what did it stop the fracker from doing?
He had to put in place procedures that cost investors in the small funds about...
Susan, you give you...
What do you mean with these procedures?
I'm not
to
going
him
to
as
get
a
into...
punitive, or were they...
I can assure you that the burden was onerous from them and for the
What was
investors
the
in the
purpose?
fund.
I mean, surely it
And they
wasn't
were
just to
doing
kind of go out
nothing
and
wrong,
spoil
but
his
it
day.
was just-
Sorry, I want to pick on this point because it's very easy to throw it out there and say, oh, well, it's terribly burdensome. I don't think the EPA woke up any particular morning and said, you know what, we're going to spoil their day.
Why don't you invest in some energy companies in Colorado and you'll see what those burdens became.
But do you want to ask or understand what the EPA was thinking? Or indeed what any other federal agency was
Government
doing?
overreach. That's not their
But
role.
that's not going to be wake up in the morning and say, I think I'm going to make somebody's day
I
terrible.
actually think they do, and
that's
I was official of that. They wake up in the morning and they say, can we take down this small...
Well, Susan, let me just say this.
Sorry,
Let me just say this.
That sounds ridiculous.
Yeah, let me just say this, though, and to split the difference here. California realizes that it overreached with a lot of its environmental regulations, for example.
And oil in particular.
They've realized it, but see, history didn't start last week or 2 years ago. There was a reason why all these regs got put in place, so the pendulum was swinging, and now it's got to go back.
Correct.
So there's a logic, there's a rational way to deregulate and recognize you made an error in some of your regulations. So in that regard, I can agree with you. But there is an assumption when people talk about deregulation, you know, you hear what I said about what I think our industry has gone through. But regulation is the price of civilization. There are going to be errors. And there's always going to be a discussion and argument about it. Anthony, you had your...
Yeah, I think the topic is broader than just the specifics of that particular case. The topic is really about rulemaking. And where does rulemaking stop and legislation needs to begin? So it's our legislators that have been making broad brush legislation and then dropping in a supposed experts pool for them to write the rules around it. So I think that's the topic more so than whether it's right or wrong or too much or not enough. It's not specific enough as it relates to these topics, and who has gone beyond their mandate as it relates to puddles being ponds, or I mean, we can throw out 1,000 issues.
I can give you 1,000 issues that have happened with people of mine, friends of mine, or
Well, I asked her for one, and you
I
couldn't
did, and you don't want to listen. So all I can say is that I agree. There needs to be more specific rules written. Our legislature has abandoned that, and therefore government overreach has been oppressive on many small businesses, because they're the ones who can't possibly comply with all these regulations.
Well,
All right, so
let me play devil's
Let me
advocate.
interrupt. You're going to
Continue to
have
have
a
because I want to put one out there.
Yeah.
You may not like legislators going and crafting very vague rules, but then you'll have agencies come in and be very prescriptive on top of it, and have that very thin legislative basis and go and construct all of these regimes. I will guarantee you, you will hate the idea of legislators spending years and years and years with highly prescriptive legislation that binds regulators to do very narrow things and gives them no discretion. I think you'll hate that just as much.
Well, where does it exist?
Yeah.
Where have you seen that?
Where have I seen personally?
Yes.
I spent 20 years of my career in Europe working
Oh,
on
you're in
exactly a bit the
Europe?
same.
So the BIS's rules are all imprinted in law?
Well,
The BIS is not a regulator.
I know it's not a regulator,
So it doesn't have-
but I mean, it's a kind of an independent
But no,
outside
if you
of the
want-
realm, I
you know,
guess.
If you want to see a good example of it, we have a doctrine in law
We're
that's
not
simply
Europe,
to-
we're the U.S.
Right.
We
Hold on a
want
second,
to
guys.
I'm
live-
still-
Let's hold on. Let's. This is fun. I'm enjoying this.
Well, I never said
I'm
that.
just trying to give you an answer. And the answer I would give you is the Moroni Doctrine. You've seen financial services
The
legislation.
Moroni Doctrine?
The Moroni Doctrine,
Mhm.
financial services legislation, European Commission, union law there, never granted any discretion to supervisory authorities. They had to do what the law told them. They couldn't decide, oh, this is a bad law, we'll have a no action relief. It took us years to get that into the powers and into the regulations for the European supervisory authorities.
Yeah. Okay. I want you to finish.
Sorry.
Okay, so this is great. So we're gonna maybe we'll be here till like
number
midnight.
3. What is this
Yeah,
thing
go ahead,
about
go ahead.
number 3?
Just one more point on the Chevron overturning. So I want to, point out that with Chevron gone, it cuts both ways, right? Because when Chevron was, decided back in the 80s, it was Reagan's era, right? It was Reagan's EPA that had actually proposed a more relaxed rule before the Supreme Court. I think it had to do with the sources of air pollution coming out of the factory, and Reagan's EPA had suggested an interpretation of the rules that had relaxed the regulations for those particular industry actors. And so it's not really about a left versus right, a Democrat or Republican thing. It's about certainty, right? So in theory, Chevron should be working where regardless of it depends on the administration. It's the administration's agency's interpretation. So whether they want to go a more deregulatory approach, then that's how the courts would interpret it. But now you've pulled that that deference from the agencies, right, which are normally directed by the executive, of course, to district court judges. And they could, district court judges are across a wide spectrum of beliefs, they could have certain, interests themselves, and so you're kind of left with a wide open field of possibilities, shifting sands, I would say.
I think you're left with more state rights. So as someone who is more for state rights, which is something Europeans are less familiar with, is someone who's for that, because I think states can dictate their own rules to advance their own economies.
But district court judges are federal appointees.
Yeah, I understand. Therefore, you can appeal those judgments to the Supreme Court, okay? And over time, you'll have a bank of legal opinions that will effectively correct the overreach. Because, whether you like it or not, government agencies, or especially in the EPA, are frequently filled with more left-wing agenda people than right-wing. Because right-wing people are more about freedom to do what you want.
Well, look at Trump's EPA now. I mean, he's
bringing it all up, okay? Which is too much of it, I agree. That's good, as David said, swinging the other way. But, the fact that we have all of this natural gas up in New York, and we're now running a huge deficit, and we can't take it out because of state overreach. This will be addressed, I think. And these are the kind of things that a state and a country needs to think about, all right, which has been not part of the calculus under Chevron deference, okay? And but I wanted to hear about this private funding.
Another question over there, Dave.
I just wanted to say, I maybe that statement, even local, like Corpus Christi, Texas, you could cut the air with a knife. It's so thick. I don't know, if I was a resident there, I wouldn't be too happy. You talk to some people who are near some data center now, the noise, they can't even, it's like a steady hum, they can't even think straight. The water's brown. I mean, the electricity rates have gone up in many places where you have these data centers, and it's going up for everybody. I mean, that doesn't seem very fair. There's this thing that I learned back in business school that I think all of us know, externalities. There's all these externalities. So it seems like if you're some laws should be local. Like if you have some big-ass data center coming in and it turns your water brown and your children get cancer, I think it shouldn't be that some local official gets a nice big bribe, a nice big Cadillac. It should be voted on by the local people. Do we want to have this big-ass data center right next door to us?
I want to, just in the interest of time, because we were supposed to be opening up to questions, and we're having, everybody's now a panelist. So, I just want to say this. I want to say something. I personally consider myself kind of a bridge builder on this. While we are dealing with how much regulation is not a quantity, it's not milk you pour out. Is the specific regulation rational? Is it working? Right? That's the issue. Basically, my comments tonight are on the right, because what's happened in our industry has been horrendous. Under Geithner. So that doesn't mean necessarily that you just take the bottle and just start pouring regulation out, right? So it's a rational process. It should be a rational process, and it will always be political. So, but I want to make sure you get to finish. So go ahead. No more interruptions until she's finished.
Sure.
Okay, go ahead.
Okay, thank you. But yeah, no, Susan, I think you'll like these next two or three decisions. Basically, what's been happening is, there were a couple of new rules proposed under the Biden administration. This one, National Association of Private Fund Managers, the SEC. This one, where it was a Biden rule put forth by the SEC, where private fund managers. There were some new disclosures for some private funds. Yeah. And essentially, what's been happening is, we had a lot of industry actors pursue cases against the SEC, and they've been blocked. So that's what's going on with that one. And then we have this next two cases concerning DOL, Department of Labor. There were some rules also implemented under the Biden administration with regard to fiduciary duties for industry professionals who provide advice or investment management expertise on retirement securities, right, or those types of accounts, and basically insisting that they follow Reg BI, best interest, with regard to those products. And this one, essentially what happened in district court was the district court had agreed to stay the cases, and then when Trump came into power, Trump 2.0, his government was able to successfully petition the court for a motion for abeyance, basically putting these on pause. So you can say that this one was also blocked another Biden-era administrative statute.
Well, what do you think of that one, David? The last.
Dirk, if you.
One second. Sorry.
Do you think that we should have? These are not RIAs.
There's been a lot of
RIAs are regulated. They all have fiduciary responsibility.
Yeah, there's been a lot of fund rule proposals. I mentioned one that would have imposed obligations on CLOs to get audited. There's been regulations proposed that would have looked through the registered manager or the registered investment advisor to force private funds to get audited when there was no need for a Cayman or a Luxembourg fund to be audited. So you're basically regulating, open by looking through your U.S. regulated, and you're actually regulating the foreign fund. Otherwise, you can't manage the assets of that fund. This is crazy stuff that was coming up. I think crazy.
I agree.
So there was an
We had a
overreach.
number of private funds that are offshore.
Yeah, exactly.
And that was total government.
Yeah. There's been, Conor's going to speak about all the other regs that were pulled, or where the compliance dates were extended. So, but it's been. Gagner was out. He was really working hard to.
I mean, Gary.
I'm sorry, Gary Gensler. Yeah, Gary Gensler.
I hated word.
Yeah. So, Conor, do you have anything?
Oh, I have one.
Okay, one more thing.
Yes, I was very vocal. I didn't know.
BJ, if you can go to the next slide. Thank you so much.
Law enforcement action, 1 month.
So, I had mentioned, recent challenges to, SEC authority, particularly with the Jarchese case, with essentially SEC enforcement actions being involving civil penalties, moving to federal court outside of, SEC administrative hearings. Well, what effect does that have on FINRA enforcement, of course?
Right.
And so, if the SEC is not pursuing these enforcement actions, well, FINRA has been picking up the charge since the beginning of the year. So if you think that you might be safe from SEC enforcement actions, FINRA has actually been taking on far more of that load. But there's actually some recent challenges to FINRA's enforcement capabilities, which have been coming down in some recent cases. So I'll point you to Blankenship, which is Blankenship and Wynn, actually, these first 2 cases. These were failed challenges to FINRA authority regarding arbitration and enforcement. In Blankenship, essentially the plaintiff had alleged that FINRA didn't have the authority under Jarchese, right? Because, basically stating that because FINRA is administered by the SEC, why would FINRA have the authority to institute enforcement proceedings? Any FINRA member firm or participant would be would enjoy the right to a jury trial, right? So this should be decided in federal court. This was actually dismissed on procedural grounds. We never had the full opinion on the matter from a district court. So I believe that this is going to be an open. There's going to be more challenges to this, to FINRA's enforcement. So I think that's something to keep in mind as industry participants, that, we might be in a brave new world when it comes to FINRA enforcement actions. They might not be taking place in front of, a panel of administrative or arbitrators in front of FINRA. It might be happening in federal court. One way or another. Could be. There's definitely benefits to arbitration. There's also some not so great things. So that's what's going on. Wynn was also a failed attempt to curb FINRA arbitration requirements. Essentially, if you are a member firm, you might have an issue with another member firm. Oftentimes you're compelled to arbitration, industry arbitration under FINRA, right? And so Wynn had argued unsuccessfully to district court that under Jarkizi, there is no obligation for FINRA to force industry participants to FINRA arbitration. That was a failed attempt. I think the court said that he can't use Jarkizi as a get out of arbitration free ticket, and so that was a failed attempt. But I do want to point everyone's attention to Thrivent, which is this third case here. Basically what happens is Thrivent Financial has made a petition to the DC Circuit Court of Appeals, essentially asking that FINRA's rule regarding private arbitration is abrogated or completely eliminated in this regard. So what we're seeing is a move away, probable just based on how we're seeing the judiciary these days, move away from FINRA arbitration, FINRA enforcement into the federal court system. So, I have worked in FINRA arbitration before. Say what you will about it, it is quicker than the federal court proceedings, but like I said, we're on shifting sand. So what I would recommend to everyone in this room is pay attention, subscribe to the main news alerts to see where this is going in terms of where disputes in our industry are headed. Because like it or not, I think we're going to be dealing more with federal court cases than arbitration.
How does that affect when you sign a client contract, right, for investment management? You have in there restrictions and you have to go to arbitration first. Is that going to impact that?
Yeah, certainly. So normally what happens, my experience is mostly in broker-dealers, but typically what happens if there's a customer dispute, this is required to be played out in FINRA arbitration. So based on these recent challenges, we might be moving away from FINRA arbitration and into customers being obligated to make their complaints through the federal court system. I actually think that's more expensive than arbitration, I would say generally. It's going to cause customers to not be able to pursue as many claims against industry participants, for better or for worse, right? There's a lot of, specious customer disputes that are levied against firms, sure, but a lot of them have merit, right?
Yeah. I'm going to go to Conor now because we're going to run out of time.
Sorry.
He should have his full time.
I think I could give a perspective of something outside of the support function. So my day job is on the front office. I run a swap desk. And amongst any of the activities, it's probably one of the more highly regulated activities in the US. Security-based swap dealer, I'm an AP for that dealer. I have to be licensed. I have 724 for those purposes. And everything I do is essentially a contract, a variation of a contract based on a master's agreement, whatever it's going to be. I price a swap, I execute. It's regulated activity. It doesn't matter if I'm, dealing with a 40 Act counterparty or a private fund, or even an individual or a corporate offshore. As I can see it, I suppose my front office perspective on this is there will be regulation, there will be compliance requirements that are going to seem tedious. A good front office team is going to know the law and regulation as well as your compliance team. And, probably doesn't spend as much time doing it as your legal team might if they work on regulatory matters. Our team at Marex is very experienced in it, so we have done it for a long time. Normally, if we know and we're up against, at the margins, something, we'll have a good reason for understanding what it is. We know that if we're coming up against it, hey, there's an issue here, we may not like it, we understand that there's going to be a cost to going and taking that risk. As I look in in a deregulatory environment where, say, for example, the commission under previous leadership will take an awful long time reviewing products. I'm seeing products come, registration, registrations being made effective for products that are probably not going to be a great idea. Ones that are more accessible to retail investors. We see it most pronounced, I think, in crypto, but we can also see, very curious, I think, valuations, not honest valuations in some companies because they decide to pursue a strategy that is a plausible one. I can see this all ending in tears, as my mother used to say. In terms of a deregulatory agenda, I don't think it meets the definition of an agenda because I don't think it's that well organized. I think you have in some cases agencies that have no leadership. CFTC is a good example. You have one acting chair doesn't appear to have any particular interest in even enforcement. And the only thing that I've seen the CFTC do, I think, was a very curious publication of interpretive guidance for one firm that, to my mind, really opened the door to broad offshore management crypto business and doing that really through the US, just going offshore, back onshore, and being able to outsource a lot of activities. I don't think that is necessarily a good or healthy or positive sign to where we're going. I was discussing this in my workplace, and the concern that we would have that is advantageous as it may be at this point in time, understand that that pendulum will likely swing back. And what we do now in the current risk-on environment, where there seems to be little prospect or fear of enforcement action, that may not be the same, and it won't be limited to a short look-back period. It could end up a change of government in 3 years hence, and an incoming administration that is looking to go back to what was the agenda of the Commission under Gents or maybe other agencies that were more active in their enforcement matters. Again, I can speak as a foreigner and consider myself separate, if not above the fray on politics in this country, but I don't think having no rules is a good thing. I think there's a reason why you have these. You may not like it, they may add costs to business. They're not intended purely to diminish the bottom line of businesses. Anything that would do that, you would hope would never make it, out of committee. You would hope it would never survive even, the first legal challenges. I think in financial services, we have to be careful that it is generally other people's money that we are working with, and some level of appropriate regulation around that is going to be important. I think if you are managing a private fund, were I an allocator, were I an investor, were I prime brokerage on our prime brokerage team, if I were seeing a very hostile, competitive, we're going to be so fast and nimble because we don't care about the rules. Okay, that's interesting. You're not getting my money. I'm not going to recommend to any office that we would put any money with you whatsoever. I think we need to be sensible in a business that there is an appropriate balance between rules that are, okay, fine, this is the cost of business, and yes, I might agree with this, or no, I may not. I understand that there are some rules that I think if we roll too many of them off, we're likely to get bad actors. We are likely to see more harm, and we are likely to see that damaging good actors as well.
Yep. Just one comment and then we'll open it up. So again, I think a lot of the arguments around this issue of regulation is if you listen to the news, it sounds like it's about quantity. So category error in thinking about regulation. The issue should always be, is the regulation necessary?
Yeah.
Is it doing the work it's supposed to be doing? And of course we're going to be fiduciaries, but just one one example. 100 years ago, before Regulation BI, right, came out, if you were an investment advisor, you had to make sure that Schedule F of your ADV was given to the investor before they signed the contract. That was not bad. That seemed to work pretty well. What are we really achieving with what Gensler suggested we should be doing here? Is it really workable? And let's not, with all due respect to Conor, and I kind of agree with much of what he said, fiefdoms do get created. They get created in law firms and accounting firms, no disrespect. They get created in universities. And and we bring a lot of this crap on ourselves in the industry. Let's be honest about this. When we do that, the politicians get into gear and they allocate a whole new pot of money to regulators to go take care of the problem, which is what Dodd-Frank did. And of course, they have to now hire a whole new army of people to go out and regulate and check boxes. And now we're all stuck with that, right? So, a rational process of regulation is necessary, but I don't think we should simply just give a pass to say, well, we're fiduciaries, so, we've just got to do all these things without pushing back and asking intelligent questions about the nature of the regulation being imposed on us, which is what I think I was starting out with. So, yes, first not first question, because you had Susan before, but go ahead.
Nothing to do with Susan at all.
Okay.
We're just sitting next to each other. I'd like each of the three of you to make a comment, because I know we're getting near wrap-up time, on looking at all of this from a completely different perspective. For the small to mid-sized investment firm, with everything that's going on, what is it that you recommend that they most keep an eye on where there's a moving target right now? Conor, you want to start?
At the risk of giving a general answer that everybody's going to say, well, I would look at their reporting obligations, and as a small firm starting off, ensuring that they're getting that right. And the best advice I would have is, even if you are worried about it changing, always try to over-comply. Say.
Okay. As a investment firm, we're in a deregulatory environment, right? So, I think if anything, any sort of regulation changes, it's going to lessen your burden, theoretically, right? But I think, you need to keep the eye on the ball of where enforcement is coming from. If we're seeing enforcement move away from the SEC, maybe move more towards FINRA. I would just keep an eye on, who's holding the stick at the current moment. I think in terms of enforcement actions, I think don't let your guard down. Just because we're in a deregulatory environment, I'd say, if now is not the time to completely, move your systems away from where they have been at before, because things might change back in the future. So, yeah.
Yeah, that's my answer. For the most part, I would add this. I always think about the principles of my client firms, that you don't have a red dot on your forehead. If you're a principal, if you're an executive of the firm, have regular meetings once a month, have a raft of things to go through, discuss them, have some accountability inside of it, make sure things I don't think much is going to change. I think the way you're doing things now, if you're doing things correctly and you're getting through your examinations, when you're examined, you're probably going to be fine. The other thing I would do is, as I said, I'm telling all my clients to look at their manuals. It doesn't have to be one discrete document. It could be a number of different things. But make sure what you're saying you're doing in those manuals you are doing, and use some language that is somewhat exculpatory. One of my favorite Latin phrases is inter alia. We're going to be doing this, and this, inter alia. You've got to have some wiggle room for the principals of the firm, because they're busy. If you're trading all day, and as well as your team is in terms of regulation, that's not what you're doing. You're trading. So your focus is elsewhere. So, try to remove as much risk from yourselves as possible, and you do that with your documentation, and you do that with a regular process. I've had clients over the years incredibly lazy, actually refusing to have a monthly compliance meeting or monthly compliance report. And I warned them, I said, this is going to end badly for you, because you're taking your eye off the ball. So to Megan's point, I just keep doing what you're doing, and have a discrete methodology, a rational methodology to make sure you're on top of things in your firm. By the way, the other thing I'll say on this, if you're the CEO of your firm or one of the senior people in the firm, COIA covers a lot of sins. When you're covering yourself, you really are also covering the firm.
Yeah.
So, that sounds cynical, but it is true. So if you don't want to go down, right? Well, if you do the things so that make sure that you're not going to go down, you're probably going to make sure the firm's not going to go down either, or wind up with a regulatory hickey. That's not directly in response to your question, but I wanted to say that anyway.
So, David, if you're the CEO of a firm, to your last point, what you want to do is surround yourself with a lot of 24s. Okay, so that they can take the hit if there's a problem. But,
That'd be very scarce, but when you come up with your latest trading strategy. You know what? I didn't see Bob when he came and he put that on, and you'll have to talk to the clearing firm about why that out.
Absolutely. But I just want to say this is I think many people in this room can identify. We've all been through audits with FINRA, with the SEC, and they can be tough. There's no question about it. But I just want to say, and I think maybe echo some of the points made by the panelists, that I think you were saying this to a certain degree. In my opinion, if it weren't for the fact that we have the 33, the 34 Act, the 40 Act, the American capital markets would not be the beacon that they are. Okay? And regulation can be inconvenient, and I think if you go back to the days of the New Deal in the 30s, when these regulations were conceived, and they came up with the idea of self-regulatory organizations, the government understood that they did not have the expertise or the resources to regulate not only securities, but trucking, everything else on the planet, right? So they deferred back to the industry, and that's supposedly what we have, okay? However, with the Chevron case, you can see where it's been, these responsibilities have been delegated to unelected so-called bureaucrats. And I think, David, you said this, the pendulum has swung back and forth on this thing. So a question I would just pose to the audience, to the panel, is who are the experts? Because this, if you went back to 1925, this conversation would be incomprehensible, okay? Because at that point, not only were the Republicans, but the Democrats, okay, all believed in balanced budgets. They didn't believe that government should be as intrusive as it's become, okay? Then we had something come along called the Great Depression, and that caused us to rethink everything. So we've been living in the specter of the Great Depression, of the New Deal. This is a byproduct of the New Deal. And while I'm not a lawyer or a legislator, I have been around enough legislators to hear the following. They get appointed to committees where they make the laws, but they're not experts. Okay, they're elected officials, but they know nothing about the subject matter. So where do they draw for that expertise, right? Well, there's lobbyists, but that's a dirty word. Okay, and then there are bureaucrats, right? And I don't say that in a negative way. These are lifetime government employees who supposedly have expertise in that field. So I think that's the balancing act that we have here, right? Is on one hand we want the free market to tell us how the market should operate, right? But on the other hand, we want someone in the middle, someone who's fair and not arbitrary, and hopefully has expertise, not just in the law, but in the subject matter, right? And that's not so easy. So I'm just curious, what do you folks think about that?
Well, for the bureaucrats, I think what's in order for bureaucrats is restraint, right? To not, building these fiefdoms, as I said before, is what leads to the problem, the suggestion that there's just way too much overreach, that Congress never intended unelected persons to have. By the way, that argument is specious to me. The unelected argument is always used because our system is set up so that accountability is handled the way Congress decided it should be handled for the most part. That's fine. There's nothing wrong with that. But I want just one point about this, and I'll shut up. You mentioned the 34 Act, you mentioned the 33 Act, you mentioned the 40 Act. most of these regulations, these bodies of law, were the result of scandal and pain, credit mobilier, the Ponzi schemes, Teapot Dome, all of these things. So they taught the government where the troubles are, and the regulation was built around it. Look, we're all intelligent people. We don't need to make this a partisan thing. Do we have silly regulations? Yes. I just told you about some of them. We didn't even get to them all. Yes, we do. Does that mean you can just turn over the bottle and pour out a quantity? That's stupid, frankly. That's not how you do this. You do it. And by the way, there's a whole department, this idea of, there's no mechanism in Congress. There's a mechanism. It's called OCIE. It looks at regulations. It's way too small. It's attached to the White House. And it looks at unnecessary regulation. What people don't know about the Obama administration, for example, is that Cass Sunstein was appointed to head OC and get rid of a lot of regulations. So if we can stop being partisan on this issue and start being rational and say, what regulations are silly and we don't need anymore? They just did that in California with environmental regulations. But again, we forget when we have these debates. History didn't start yesterday or the last election. And with respect to environmental laws in this country, and I teach environmental philosophy, with respect to environmental regulation, there was a reason why we had to do what we did in California and elsewhere. Remember the smog in 1975 when you flew to LA or whatever year that was? Well, what happens is the pendulum starts swinging now in favor of robust regulation of the environment. Yes, but now it's too much. Now we've got to think about what regulations are now harming the economy, progress, and we have to find a way to split the difference. That's a rational approach to regulation. So, you guys.
Yeah, I well said. I think for when it comes to decisions like, Loper Bright turning over Chevron, yes, of course, when it comes to deferring to the regulatory agencies, whether it's an SEC under, a Republican administration, under a Democratic administration, we see, this pendulum swing between the two, and we defer to experts under both administrations, right? That makes sense to me. I think what worries me is that we have a judiciary that's just thrown out the rule book entirely. And by the way, Chevron has been around since, like I said, it started under Reagan, or at least, during his time with his EPA. Went through Clinton, went through both, Bush terms, Obama, first Trump, right? And so I think that when we're throwing out this rule book that's, 40 years of precedent, it just kind of opens the door to what else is possible. And I think, in my limited experience, I know that markets enjoy, predictability, right? I mean, I think we can all agree that, when we know what the rules are, when they're consistent, we can, act in reasonable manners to find out what is the best way, what is the best investment. But when we completely, when we're so willy-nilly with throwing away, established principles over time, that's what stresses me out, right? I think that's what worries me about where we're going in terms of this regulatory environment. Of course, during a Republican presidency, of course there's going to be deregulation, but decisions like Loper Bright, that's not going to be reversed for years. It's not going to be addressed for years. We just don't have the congressional willpower, and our Supreme Court, it's going to be locked in the way it is for decades. So
when the judiciary gets clogged, then it'll get addressed. Someone had there. One more question. Yeah, in the back.
Okay. JB, you want to first?
Yeah, I don't need a microphone. I have a compliment, a quote, and an observation. On behalf of all of us, thank you guys. You guys will be great. You're really special. Your talents, you're special. A quote. 66 BC, Cicero. I'm a frustrated Stoic philosopher. Become a slave to the law, will set you free. If you don't like the law, change it. It's simple as that. And now the observation. One of my companies I'm involved with is a post-trade processing company. I'm so happy to report to everyone. The regulators are being more realistic. They're being more cooperative. They see the future. I know my perch is very myopic, but after 47 years, I'm entitled to say this. It's refreshing to see FINRA now being more realistic, more cooperative, and understanding where the new world is going. I just wanted to share that with you.
And there's no such thing as a frustrated stoic.
No.
So,
Yes.
I think this is a good forum to ask this question, actually. Equal Opportunity for All Investors Act of 2025, since we're talking about the great regulatory rollback, where I think I'm of a younger generation and I can be considered an accredited investor if this goes through. So I just want to understand from you guys, is it a good thing or a bad thing? Again, so an accredited investor, we all know what it is. $200,000 in income if you're single, $300,000 if married, $1 million, not including your primary residence. It's got bipartisan support in essence because it was proposed by a Republican, I believe, in Nebraska and a Democrat in Delaware. Pretty much said, hey, the SEC should make a test to become an accredited investor. FINRA would have to administer this test. So my question to you guys, just quick 2 seconds. Is it a good thing, bad thing? Because I've heard both sides.
That we have a standard for
If
accreditation?
it goes through.
I'm sorry.
If it goes through.
The test.
A new test.
Lowering the standard.
Yeah, because it's in the Senate right now.
Go ahead.
I think we've been whittling it down for a long time.
Yeah.
I think it's become meaningless. So I don't think it's good. I don't think it's going in the right direction. The idea of, and I fully accept, you can't stop people from making stupid decisions with their own money. But you can at least try to protect maybe the more vulnerable and to limit certain things. It's very difficult to draw the line. But I have to say, on balance, my feeling is I would make it more restrictive rather than less.
So Connor, if we do that, right, then maybe we should have a test for buying microcaps.
Or indeed, Farcoin.
Well, listen, you can't buy microcaps today because the industry has made it very difficult for any investor to access the microcap market.
No, indeed, we should all be buying private credit.
Oh, First Brands is great.
Well, we actually have one here, so anyone is interested.
Well, there is a rule about buying microcaps, low price securities. FINRA has a rule, 15G, requires disclosure that you're doing it. What, by the way, kind of on this point, I just bash Regulation B. I don't like it at all. I think it's badly constructed, and I think it's silly. But take the marketing new marketing rule.
But before we do, I want to give our colleagues just an opportunity to get an alternative view to mine.
Yeah, go ahead. Did you want?
I know I answered this question.
Yeah.
You guys can.
Meg, any thoughts? We talked about it earlier.
kind of did.
What do you think?
I think with the accredited investor, scheme, it's supposed to, allow investors with more capital to make riskier investments, right? But if
Which is good for my business.
Sure, and with
I'm on the
this,
audit side, everyone.
sure, and with the the rollback of this, more accredited investors, I don't think it's about industry knowledge or knowledge about investments. It's about risk tolerance. And so if you have people with less capital doing more risky investments, you're having more loss. I don't know if you have a doctor who just passes this test and then loses their savings to like a wildcatting scheme. How is that? I'm with Connor. I don't know. I think it's a bad idea.
Well, I find the accredited investor standard is curious. I don't really know the legal banter that went on when they adopted the rule, but I'll say this. It's arbitrary to some degree what the level should be. And what I was going to say before, we have this new marketing rule under the Advisors Act. They're supposed to be modernizing things. Well, I like the old rules better than the new rules. But if you're modernizing, people don't read. People don't read their prospectuses. They don't read nobody reads this stuff. Nobody's reading your CRS document. have videos, use different technology, talk to people face to face. Say, you want to buy into this private credit? This is what you're risking. And so have appropriate ways to reach people, really reach them, instead of putting another document in front of them saying, here, and by the way, the other thing about the accredited investor standard and the other standards, qualified purchaser standard, all these other standards, is that it's funny, the SEC was always, the philosophy of the SEC has, and you can speak to this maybe better than I can, has always been disclosure. That's the basic philosophy. Having standards like a credit investor standard or a qualified, it kind of was what the states do more than the federal regulators. But, I don't know what the number is. Who knows what the right number should be? I mean, by the way, if you've got $200,000 or even
In the tri-state, that's not that hard, but obviously if you're in lower income states.
Yeah. But even if you got $1 million in investments,
Yeah.
you really can't afford to lose much,
Yeah.
right? You can afford it because you'll be able to buy groceries, but it's going to hurt your family. It's going to hurt your prospects for the future. I think that there are other ways to address this, so I'm not going to weigh in on what the level should be, but
The question, David, is really, is it appropriate? You can, once you meet the accredited investor standard, you can bet the farm.
Well, what's appropriate?
I mean, it really isn't an appropriate measure.
It depends on what appropriate means. It's like it depends on what the meaning of is.
Well, the only way to control that is to limit risk, right?
But you want to limit risk.
Limit risk with people that can't absorb the risk.
Sure, but now let's take why these thresholds come into being. The qualified purchaser standard came into being because the 3C1 standard was too restrictive for funds. So they made a standard where let's loosen this up a bit so that the funds don't have to worry about counting who's coming in and reaching that 100 investor threshold. So these standards come in for different reasons, not necessarily to protect, and by the way, the other obligation the SEC has, the regulators have, is to maintain markets that work, to maintain a marketplace that works. It's not just all investor protection. The marketplace also has to be addressed, and there should be fairness to the participants. All of it has to be thought through. That's why what we're doing tonight is actually quite healthy. A rational conversation about this stuff, not partisan, not ideological, I think is the best way to address regulation.
Yeah, we can end it there.